Welcome to One Square Feet, where we decode the complex laws shaping India's property and real estate in a very plain, practical language which become easy to understand. I am your host Anil Diwan, and today we are going to talk about something that lies at the heart of every real estate transaction in India, that is concept of possession, ownership, and title. And confusing them can cost you your money, your peace of mind, and sometimes even your home. So let's rethink the fundamentals. Let's start in a very simple way. Ownership means you have the complete legal right over a property. You can use it, sell it, lease out, or mortgage it. No one is going to bother you. Title is your proof of that ownership. A legal paper trial that says, yes, this is a property is truly yours. And the possession, if you talk about the possession, that's just a physical control. Occupying or using the property. A physical control to occupy, use the property. You might live there or rent it, but that doesn't make you the owner of the property. Possession, if you think that you are the possessor of the property and you become the owner of the property, you are wrong. That doesn't make a full ownership of the property. Here is a catch. In India, a lot of people mistake possession for ownership. If they have possession, they believe that they are the owner of the property. They buy properties on power of attorney or unregistered agreement that is not registered with the sub registrar, thinking they are the owner of the property. But legally, they only hold a fragile possession or a possession that can vanish overnight in a courtroom. Now, if we talk about sale or agreement to sale, it's a very different concept. The Transfer of Property Act 1882 draws a clear line here between a sale and agreement to sale. A sale means immediate transfer of ownership through a registered sale deed. An agreement to sale, which we call as the ATS, on the other hand, is just a promise or a contract to sell in future. That is, we both agree. The seller says, yes, I agree to sell the property. The buyer says, yes, I agree to purchase the property on the said terms and condition and the consideration. Even if you have paid the full amount and taken the possession, until registered sale deed is executed, you don't legally own the property. You are not a legal owner of the property. You can't mutate your name. You can't take a loan against it, and you can't sell it out. Your only remedy is to approach the court for specific performance, asking the seller to complete the sale formally. All compliance or all law formalities have to be complete. In a simple terms, money plus possession without registration equals no ownership. You are not owner of the property. Now you might think, I have registered my document, that means I am safe, right? Not necessarily. Answer is not necessarily. Under the Registration Act 1908, registration is a procedural safeguard. It gives a public notice, records the transaction in the public record, and ensures priority. But it does not guarantee the ownership. If the person who sold you the property never had a valid title, even a registered document won't protect you. It's a very important point to be noted that a defective title, if given, is also defective. That means if the title of your seller is defective, you also get the defective title. You can't say that my title is clear. Now, a beautiful stamp, perfectly registered sale deed can still collapse in court if that is a court of law, if the underlying ownership is defective. What I said, a defective titles still remain defective even if transferred. The upcoming registration bill 2025 promises a digital registration, biometric verification, and integration with the land records. All great for transparency. It will bring a great transparency in the Indian real estate market. But remember, technology strengthens process, not property right. The law will be there. A digital signature can't fix a broken title. A digital signature can't make the title from defective to a normal title or a complete title. Now, if you have paid, taken possession, and fulfilled your part of the deal, but the sale deed is not registered, Section 53A, also known as the Doctrine of Part Performance, is very important to understand. It gives the limited protection. It allows you to defend your possession if the seller tries to evict you. But, and this is very crucial, it does not make you the owner. You can't sell, transfer, claim title. It's a shield, not a sword. That means no one will throw you out from the property because you have paid the consideration. You have paid consideration, you have executed deed, but your title is defective because your seller has given you a defective title. Defective title once transferred also remain defective, which I have told earlier also. Now, after 2001 amendment, even this protection is available if your agreement is registered. Unregistered deals, handwritten agreement or power of attorney steps now means legally speaking almost nothing. After 2001 amendment, even this protection is available only if your agreement is registered. Unregistered deal, handwritten agreement or power of attorney will never hold you as a owner of the property. And with the new registration bill pushing digital compliance and biometric trials, the days of informal possession based property dealing are ending fast. Now, Supreme Court has been crystal clear on this and have given a landmark judgments. In Suraj Lamp and Industries versus State of Haryana, the court ruled out that the power of attorney or agreement to sell does not transfer the ownership, only registered sale deed does the transfer of ownership. In Thompson Press versus Nanak Builder, the court said that the later buyer cannot override an earlier buyer's agreement, but the original buyer's right remain equitable, not ownership, until sale complete. And in K. Gopi versus sub-registrar, the court clarified that the sub-registrar are not the title verifiers. They only ensure documents are properly presented and stamped. They don't certify the legality of the property. Ownership arises only from a valid, lawful, executed and registered conveyance, that is a sale deed. Now, very practical 5 advisories from my side. The first one is possession and ownership. Holding a power of attorney or a handwritten agreement does not make you the owner. The second is due diligence is not negotiable. Verify the last 30 years of title change, check encumbrances, and ensure the seller actually owns what he is selling, he or she is selling. The third is informal deals invite trouble. They might look easy, but they lead to years of litigation. They can save your money at that time because you can evade the stamp duty or registration cost, but that can lead to years of litigations. Now, the third point is registration title verification. Title verification very important. Sub-registrar does not check the ownership. Again, the Supreme Court has said in its judgment, sub-registrar does not check the ownership. They just record the document. So the responsibility is on you to verify the ownership of the document. The last one is the digital foolproof. Biometric system can verify identities, not the legal right. Biometric system which are going to implement just going to verify the identity of the person executing the deed, but not the legal right of the person as a seller or the buyer. In short, legal formality is not red tape, it's your protection. Looking ahead, India is moving toward the full digital registration and land record integration. We are entering a new era of real estate transparency, but technology alone won't solve the age-old problem of defective titles and fraudulent claims. Even in digital world, the fundamental will not change. Ownership flow from law, not from possession or pixel. Just like a scan can prove who signed a document, only a valid title proves who owns the land or the property. The future of Indian real estate market lies in a hybrid model that is digital convenience combined with a strict legal diligences. Because the true foundation of property is not the building, the biometric or the blockchain, it's a law. So the next time someone tells you possession is ownership, remember only a registered, lawful and valid sale deed gives you a true title. This is One Square Feet podcast and I am Anil Diwan. If you found this podcast useful, share it with your friends, clients or colleagues and follow for more insight into how law and policy shapes the Indian property market and the real estate. Until next time, stay aware, stay protected and never stop rethinking the fundamentals. Thank you.